Hey everybody! Today I want to talk to you about a very important topic, tenants' rights and the eviction process in Texas. So step number 1 is a notice to vacate. The landlord must give you a notice to vacate, and it is not an eviction. You do not need to move out.
It may also be called a notice of termination.
Tenant does not violate the law by not moving out. A notice to vacate is simply a demand for possession of the property for substantial breach of the terms of lease. Step number 2 is an eviction citation and service by the constable. Now, if the tenant does not move out by the deadline in that notice to vacate, then the landlord must file an eviction suit with the Justice of the Peace Court in the precinct in which the property is located. The citation will set a hearing date which must not be less than 10 days nor more than 21 days after the suit is filed. So, the landlord cannot remove the tenant or the tenant's property until the eviction process is completed unless the tenant abandons the property. Now, step number 3 is the trial. The trial is held on the date at the time stated in the citation. No written answers required by the tenant in the Justice Court. A tenant has a right to a jury trial, and to request a jury trial, the tenant must file a written demand at the Justice of the Peace and pay a jury fee at least 3 days before the trial date. So step number 4 is actually going to court. So the landlord and the tenant must appear before the Justice of the Peace on the trial date and be prepared to present their case, and the judge will make a final decision and sign a judgment stating which party is entitled to possession of the premises, and a tenant should always request a copy of the final judgment from the court clerk. Step number 5 is complying with the judgment or filing an appeal. If the judgment is in favor of the landlord, the tenant will have 5 calendar days to make one of 2 choices. He can comply with the judgment by moving out of the dwelling, or 2, he can appeal to the judge's decision. Now, if the judgment is in favor of the tenant, the landlord also has 5 days to appeal. Step number 6 is writ of possession. If the tenant loses and does not move or appeal within 5 days of the judgment, the landlord may go back to the Justice of the Peace and pay for a writ of possession to have the constable remove the tenant. And finally, step number 7. The constable will post a 24-hour notice on the front entry door of the unit prior to executing the writ of possession. If the writ of possession is executed, the constable will remove the tenant, and the tenant's belongings will be removed from the dwelling at the discretion of the landlord. All right, y'all. Thanks for sticking with me to the end. I hope that this has been informative for you and that it might be able to help you. If it was helpful, please hit the like button. And if you have any questions or comments, comment below. I will answer any comments that you have. And I am looking forward to doing a live stream in the future. So subscribe and check back later. Thanks.